Hi, Tony DeWitt here, Missouri appellate lawyer and a guy who likes to make the law make sense on YouTube. Today we're going to talk about a Missouri case that deals with one of the fundamental principles of negligence law called duty. Let's go down to the beach and talk about this. One of the things that frequently amazes me is how willing some people are to get into a car or truck with someone that they are really not that familiar with, and how people sometimes do things with someone, like go to a concert, when they don't really know that person particularly well. And what we have here today is a story of a young lady who got into someone's pickup truck, went to a concert, and either because she had too much alcohol or because someone augmented her alcohol with some kind of chemical substance, she eventually got to the point where she was unable to have any memory or functionality and found herself being assaulted. And that's as far as I'm going to go with that. You can draw your own conclusions. The case is out of the Eastern District of the Missouri Court of Appeals, and let's take a look at that case right now. The sad case of M.B. versus Live Nation Worldwide and Leslie Ramsey. It comes to us from the Missouri Court of Appeals on the Eastern District, and it is an interesting, if somewhat sad case. In this case are that two people, MB and AR, went to attend a concert together at the Hollywood Casino Amphitheater. They used to call that the Riverport Amphitheater, I believe, but it is now called the Hollywood Casino Amphitheater. And they met earlier to go to the concert. The young lady had a mixed drink. They went to the concert. There were about 13,000 people there. It was a hot summer day. And at the concert, she drank 2 beers. Both of the beers were poured in front of her. She never saw anybody place anything in the drinks while she consumed them. But at some point, she got very ill. Her head became foggy. She felt extremely intoxicated. And MB recalled vomiting near a shaved ice stand. Boy, that's a pretty picture, isn't it? So she believed she was given a drug to facilitate unlawful carnal knowledge, shall we say, and either by AR or someone else. So she told the guy that she felt sick, she wanted to leave early, and basically when he went to go get his truck, she didn't remember that conversation. She just remembered bits and pieces. So while she's feeling this bad, she's taken to the medical tent. Registered nurse checks her out and says, well, you've gotten too much alcohol and not enough fluid because it's a hot summer day, and you just are suffering from having a little too much alcohol in your system. So she gave her a cold towel and some water, and after determining that she was fit to leave, she released her. So she was sitting in a security tent, which is where she went after she was in the medical tent. And there's a guy there by the name of Ramsey who's employed as the operations director. And so he asks her if, her friend drives a truck. She says yes. She gets into the truck. AR takes her to, her apartment, and then allegedly did something with her that he clearly shouldn't have done, if that's the case. So a few hours later, her friend arrives and believes that she was too impaired to have consented. Now, importantly, this happened in 2016. And MB filed suit in the circuit court against respondents and AR on August 1, 2019. But the problem is that AR was dismissed because the claim was time barred. It was outside of the statute of limitations. So what her claim basically boiled down to was that the casino amphitheater, owed her a duty to protect her by discharging her to AR's care when she was potentially unable to, care for herself. And she alleged that as a result, they were responsible for the damages that were caused to her by the actions of AR, which were supposedly unlawful. Now, it's interesting, there is no mention here of a criminal case that was filed against AR. So there is some concern, at least in my mind, as to whether or not there was actually anything there that could be prosecuted, which may further make this kind of a suspicious claim in a court's eyes. But the issue was whether or not this company, Live Nation, had a duty to protect her. And the law in Missouri is that, generally speaking, a business owner is not liable for the criminal acts of a third person. So if you are standing in the line at the Quick Trip and somebody comes in and sticks a gun in your face and pistol whips you, Quick Trip is not going to be liable for that unless there were multiple other events in that same area or at that same store that would have put them on notice that this was a dangerous area and that they needed to have security to protect their customers. Well, clearly they had security at the venue, but the assault, if it occurred at all, did not occur at the venue. It did not occur except at her apartment. And so basically the defense that the venue offered up was one of duty. In other words, we did not have a duty to protect her. So the appellant cited a number of claims, but the first claim that there was a duty and that it was based on a special relationship just never made it into the record. So as I said, in any action for negligence, a plaintiff must establish the defendant owed a duty of care, that the defendant breached that duty, and the defendant's breach proximately caused the plaintiff's injury. So the first thing you have to establish is that the defendant owed a duty of care that arises out of the circumstances which there is a foreseeable likelihood that particular acts or omissions will cause harm or injury. And that's a very famous case called Madden versus C&K Barbecue Carryout. Now, the interesting part of this is that while that is indeed the law, and that for the most part there are not situations where business owners are liable, you can become liable if you voluntarily offer security and security does not do the job. But the court then goes on to say, look, even where there is an existence of a duty, it's not one to protect against every possible injury that might occur. And that's certainly true where the duty involves protecting someone from the criminal acts of third persons, and especially where the criminal acts do not occur at that venue, but occur at her own home. So, foreseeability is defined as the presence of some probability or likelihood of harm, sufficiently serious that ordinary persons would take precautions to avoid it. A mere probability is insufficient. Rather, there must be the existence of a probability which would cause a reasonable person to take precautions to avoid it. So, for example, you operate a Quick Trip and you have a plumbing issue that tears up the front sidewalk in front of the business. You have to put up barricades around the area where there's a hole because a reasonable person would do that to prevent somebody who's looking at their phone. And let's face it, we've all seen people do this. They're looking at their phone, not where they're going, and they fall into a hole. So that's why you have to take reasonable precautions, and those reasonable precautions have to be specific to the potential harm. The issue here in terms of foreseeability is how does this amphitheater foresee the possibility that when she gets home, she's going to get assaulted? There just is no way to do that. So the court in this case sums it up to extend the law and find that respondents owed a legal duty to MB under the special relationship exception given the facts of this case. Respondents are entitled to judgment as a matter of law because the summary judgment evidence before the trial court did not present sufficient facts to establish a duty on the part of respondents in relationship to AR. Point 1 is denied because a finding of no duty precludes a claim of negligence. Point 1 is dispositive of the appeal, And unfortunately for her, MB loses. Well, as you can see, that's a pretty sad case. And the thing that makes it, I think, the most sad is that what happened to her is by far and away the least terrible thing that could have happened to her. She could have been killed. If indeed she was given some kind of a drug, there's no guarantee she wouldn't have been allergic to it. She could have had seizures. She could have stopped breathing. And if one of those things was laced with fentanyl, she could very easily have died. And as a result of that, the thing that if we were to back up and look at the root cause, she did not know the person that she was going to this concert with particularly well. And one of the things that I always told my daughter is that you need to choose your friends carefully, and if you are going to go out with somebody, you need to have a backup plan, and you need to have somebody who's checking up on you. You know, I'm going to need you to call me halfway through the date and make sure that you are okay. And if I don't hear from you, I will get in the car and come find you. And that's necessary, at least I felt it was necessary, because of the fact that sometimes there are people out there with different agendas than the rest of us. And I did not want my daughter to fall victim to that. And of course, both my boys knew that if they ever harmed a hair on the head of a woman they were dealing with, that they would have to answer to me before they had to answer to John Law. So, to me, I wasn't worried so much about my boys. I knew that they would behave well. But I didn't know that necessarily, sometimes the heart wants what the heart wants, and sometimes the heart wants the bad boy. So I tried my best to avoid that. Here, it is so tragic what happened to this young lady, but it is also tragic that she believed that the venue, where the assault didn't even occur, that venue should be responsible to protect her. Several years ago, many years ago actually, when I first started practicing law, I worked on a case involving an assault at a McDonald's restaurant. And this was not just an assault, this was a drive-by shooting that left a young black man paralyzed from the waist down. As the young man got out of his car, he saw a car that he recognized, and he knew those people were not good folks, and he ran toward the door at the McDonald's. The people in the McDonald's saw what was going on. They recognized the car, and they locked the door so he could not get in. And as a result, he was shot, and we did sue the McDonald's for that issue because there had been numerous other assaults in the area, numerous other crimes. It went to a jury, and ultimately the jury decided that McDonald's wasn't liable. I always thought that was a rather unfair decision, but the reason that McDonald's won, frankly, is because they limited the amount of evidence of other crimes that should have put the McDonald's on notice, and they artificially limited the circumference of the circle where those crimes were counted. It is possible to hold a business liable for criminal acts of a third person, but only if they are aware that those are substantially likely and they need to take precautions against it, as I mentioned earlier. So, from my point of view, this case was decided accurately and correctly under the law. But the reason I list it here and the reason I talk about it here is because I know a lot of you have children, a lot of you have young women that you're responsible for, and it is frequently helpful to talk with them about these kinds of things. Yes, you will get eye rolls and you'll get from them, but if you make them aware of what could happen, when their instincts take over and they feel a little bit hinky, they're a lot more likely to do the right thing if you've had these conversations with them beforehand. So this isn't legal advice. This is, I guess you'd call it parenting advice or friendship advice. Don't let friends get into vehicles with people they don't know if they are not in a condition to be well taken care of. If they can't defend themselves, then definitely don't do that. In fact, if I saw a friend doing that, getting into a vehicle when they could not take care of themselves, I would probably get law enforcement involved. That's what I have for you today. I know it's not my usual cheery breakdown of a legal case, but hopefully you found it interesting and hopefully you found it helpful. If you have an opportunity today, go out and do something nice for somebody. I'll catch you out here on the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.